Boom. How's everyone doing? Hopefully people are having a good Monday. It's it's a Monday. That's really what I can say is uh you just sort of slog through it. You try to get your brain up to speed, you try to get everything spun up, but you do your best. That's sort of all you can say sometimes, but yeah, I mean, I think hopefully we'll have a little bit of fun here and enjoy what we got to cover. There's some fun news in the world today. um, I hope everyone's got something good to sip on, whether that's you know alcoholic or non. I myself am experimenting. I've got a clamato slash soy slash um, So clamato, soy, lime juice, sort of michelada mix, and some Modelo Especial. And we're going to just mix that up. There we go. So, Alan, so I see you're saying you want to look at some Terry Pratchett there, asking about recommendations. Now, for Terry Pratchett, there's a couple of ways to do it. You should look up a couple of maybe look up some reading orders because there's different reading orders people suggest. So yeah, you can. I I don't know. I might suggest a chronological, but that's up to you. Um, and I see somebody saying that Emily's covering the Michael Oher conservator case. Well, so am I. So, uh, yeah, that's what we're doing here. All right. There's a bunch of other stuff that we'll cover as well, but yeah, that's one that I definitely am covering today. It's one that, quite frankly, is infuriating, and we'll talk about why, because it's really going to be infuriating. And I'm just going to note, I don't follow sports. I haven't watched the movie. I'm coming at this cold. I'm coming at this going, I don't know what's going on, but let's talk about it, and let's talk about what the let's talk about what's in there. However, let's start out with an update because people are still trickling in. So I always like to start out with something a little less heavy, because otherwise I'm going to be explaining what's going on this one repeatedly. So I wanted to do an update on a case I covered previously, and that is the case of Mark Jerome Johnson Blount Esquire. Now, if you haven't been following this story, Mark Jerome Johnson Blount Esquire is a very smart lawyer, according to himself. He says that he got a, I forget what he said his LSAT score was. Can somebody remind me on what his LSAT score was? I can't remember. I just remember it was lower than mine. I don't remember what his was, but he bragged about this enough to put it into a pleading, which everybody made fun of him for, because you don't put your LSAT score into a legal pleading. So, sorry, I've still got a bit of a cough. So, just to resume, or just to reiterate what his argument was, because his argument was a little weird. So, Mark Jerome Johnson Blount Esquire says that he should be able to have a machine gun. He wants a machine gun. And his argument is not based on the things you'd think it would be based on, like, hey, here's the Second Amendment. We're going to argue Heller. We're going to argue Bruin. We're going to argue. No. He is instead arguing, like, the primary basis of his argument is that he's a very special boy, descended from very special boys. Basically, he says, because my descendants, and he actually filed his family tree as an exhibit, which is bizarre. There's times when you could file your family tree as an exhibit. Like if the issue was, if the issue before the court was something about inheritance, then maybe. But if you're filing it over guns, that's very weird. So basically, he is saying that he is, he's saying that he's a pureblood, and unlike the Muggles, he is entitled to machine guns because he has very special ancestry. He's got very special DNA. He's got very special genetics. And so basically his argument is that he's inherited special rights that are incumbent to him from before the founding of the Americas. And so he says that some people in the U.S. have more rights than others, and he specifically cites Dred Scott for that. Now, Dred Scott is a decision that you should never cite to support your position, because Dred Scott is considered the worst decision of all time, and it hasn't been explicitly repealed because nobody has ever needed to get around to explicitly repealing Dred Scott, because everyone just acknowledges that it's freaking awful. But his argument is that some people have less rights. And what he means by that is black people. So he's managed to combine like sovereign citizenry, racism, crazy bullshit, and all of that into, yeah, I made it about 7 minutes and 40 seconds. Please don't demonetize YouTube. So, what is it? So at the end of all of this, he filed this crazy lawsuit. And I was getting annoyed because the government kept asking, they said, we need more time to respond to this. And I get why. The reason why they said they needed more time to respond to it is because his argument was absolutely insane. It was noodle doodle, but it was also really long. And so they have to go through and look at it. And and hey, Steve Gosney, I don't know if you've followed this this wonderful lawsuit, but they said we need more time, and then they said we need more time again. And so finally, the U.S. has come around to filing a response to Mark Jerome Johnson Blount. And I should note, Mark Jerome Johnson Blount is not represented by counsel because he considers himself the sort of very special boy that doesn't need counsel, and also probably because I'm guessing he shopped this case around to several lawyers, and they all probably told him, are you freaking kidding me? Like, I'm not filing this crap. So, let's have a look at the government's response, because the government basically is trying to kick this out on the easiest possible route, which is to say this is stupid. So, they're basically saying he made some errors. And so we see this is the case of Mark Jerome Johnson Blount versus United States of America, Merrick Garland, Attorney General of the United States, in his official and individual capacities, the Bureau of Alcohol, Tobacco, and Firearms and Explosives. I never thought I'd be on the side of the ATF in any lawsuit, but here we are. An agency of the United States of America, and Bernard G. Hansen, Special Agent in charge of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, Kansas City Field Division, in his official and individual capacities. Now, if I were leader of the world, the Bureau of Alcohol, Tobacco, and Firearms and Explosives would still exist. It would, however, just be the world's greatest supermarket. But all right. So defendants. And so plaintiff filed a motion seeking an order from this court to permit plaintiff to serve process upon individual capacity defendant Merrick Garland by registered mail pursuant to rules. The court deferred ruling on plaintiff's motion and ordered the defendants to address same, i.e., are you okay with that? And I see blunt is pronounced blunt, like hit with a blunt object. I'm just hoping it annoys him when I say blunt. But motion for service by mail upon Merrick Garland and Bernard Hansen in the respective individual capacities should be denied as futile. What do they mean by futile? Well, we'll see. Plaintiff's complaint seeks from this court a declaratory judgment that the National Firearms Act, the Gun Control Act of 1968, and the Firearms Owners Protection Act of 1986 are unconstitutional in that said acts regulate and prohibit plaintiff from keeping machine guns. Further, plaintiff seeks an order from this court to enjoin the defendants from enforcing these allegedly unconstitutional acts as they relate to plaintiff and his desire to keep machine guns. Now, I get that he wants to keep machine guns, and there's all sorts of reasons why you might want to. Like, I would like to have a machine gun, but I'm going to make better arguments than that for all of this. So, plaintiff's claims for equitable relief sought in this complaint are spread throughout 189 pages and 491 numbered paragraphs. There's going to be some shade here, folks, because they already start with 189 pages and 491 numbered paragraphs. And yet, there are absolutely no specific factual allegations anywhere in his complaint that identifies who did what to whom, a vital and necessary element to state a plausible individual capacity claim. See Robbins v. Oklahoma. So basically, they're saying he wrote 189 pages, and yet he forgot to include some really basic stuff. Now, this is where it really helps to have a lawyer who's done this before, as opposed to a guy who is, he's very smart. I forget what his LSAT score was again. I don't care. Maybe I could look it up. But, yeah. So, in a case involving a number of government actors sued in their individual capacities, it is particularly important that the complaint make clear exactly who is alleged to have done what to whom, to provide each individual with fair notice as to the basis of the claims against him or her, as distinguished from collective allegations. So basically, if they want to sue... if they want to sue these people as individuals, you have to show that they did something. Which, yeah. I see they should check and see if ChatGPT helped him. ChatGPT wouldn't have helped him with this. ChatGPT, for all its failings, would have done a better job. Let's not malign ChatGPT in its own way. Here, plaintiff has failed to allege any personal involvement by Merrick Garland, or Bernard Hansen for that matter, in any of the alleged claims that bear upon the declaratory and injunctive relief sought. Indeed, Merrick Garland and Bernard Hansen, in their respective individual capacities, are identified only a handful of times, and each time in reference to a purported constitutional tort that has not occurred and has not been pled. Cool. There's also some footnotes, and we're going to look at the footnotes because the footnotes are also probably going to include some shade. So, although plaintiff's motion pertains solely to service upon Merrick Garland in his individual capacity, plaintiff has also sued and failed to properly serve the Bureau of Alcohol, Tobacco, Firearms, and Explosives ATF agent in charge, Bernard G. Hansen, in his individual capacity. Thus, the arguments set forth in this response are equally applicable to plaintiff's lack of proper service of process on Bernard Hansen in his individual capacity. So, basically, they're saying, we're here for Merrick Garland, but all of this applies to Bernard Hansen because the argument is dumb, and it's dumb in more than one way. And they also note, as neither Merrick Garland nor Bernard Hansen have been served in their respective individual capacities, The undersigned has not been authorized to represent either defendant in their individual capacity. Why are they doing that? Well, the reason why they're doing that is because otherwise it becomes really easy for them to serve Merrick Garland and Bernard Hansen. Because if they're represented by counsel, then you just serve counsel. So they're specifically including, we don't represent them in their individual capacity. We represent the government. As such, the undersigned files this motion on behalf of the United States of America, the ATF, and Merrick Garland in his official capacity, and Bernard G. Hansen in his official capacity only. All right. Moreover, to the extent that plaintiff seeks to enjoin enforcement of the subject firearm statutes as they relate to him, any such prospective enforcement can be accomplished only by those acting officially for the Department of Justice and the ATF. Courts have concluded that there is no basis for suing a government official for declaratory and injunctive relief in his or her individual or personal capacity. So what that means, what they're saying here is he wants to serve Merrick Garland and Bernard Hansen as individuals, not just as government officials, but as people. And he's asked for permission to serve them by registered mail or some other method. And here they're opposing that service on the basis that they're saying, like, you can't possibly win this, so there's no point giving you substitutional service because your claim is ridiculous anyway on its face. Merrick Garland and Bernard Hansen, in their individual capacities, are powerless to alter the interpretation and implementation of the subject firearm statutes and the ATF policies respecting the enforcement thereof. What that means is that if Merrick Garland and Bernard Hansen were not employed by the ATF, like if they both retired tomorrow, then they would not have any power, right? They wouldn't have any ability to change whether or not Mark Jerome Johnson Blunt can have a machine gun. So this notion of saying, hey, we're suing them individually makes no sense. That's what that's about. So finally, this court's personal jurisdiction over the individual capacity defendants is unnecessary for the proper disposition of plaintiff's claims, i.e., if he wants to make the argument he can have a machine gun, he can go against all the other people he's already named. So, as stated in the federal defendant's contemporaneously filed dispositive motion, so there's more than one motion we're going to be looking at this. This one's, and keep in mind, they're going to be able to destroy this guy in like 4 pages for this one. Plaintiff lacks standing to pursue his claims, and the Second Amendment does not grant him the right to own a machine gun. That would be the interesting debate, but we don't want, like, if you feel that the Second Amendment grants you the right to have a machine gun, and I'm not taking a position on that one today, but if you're saying, hey, the Second Amendment gives me a machine gun, the last person you want arguing this one is Mark Jerome Johnson Blunt, because you want this argued by somebody sane, like the Firearm Policy Commission. So, yeah. All right. Plaintiff's motion for service by mail upon the individual capacity defendants should be denied as futile, i.e., they want to have service on these people, but why should they get service? Because these claims make no sense. They are dumb. Throw them out. All right. So that's the first response. They actually file 3 responses. So, that's response number 1. Response number 2. And this is all the same defendants, but they are saying in support of their motion to dismiss for lack of subject matter jurisdiction, or in the alternative, for failure to state a claim. Now, you guys probably heard subject matter jurisdiction a lot when we were going over the Brooks trial. But subject matter jurisdiction actually does matter when it's not being argued by a crazy person. Now, I'm still sick, but this includes clamato, which is, tomato juice and clam juice. So it's practically healthy. We're just going to pretend. All right. Defendants, the United States of America, the ATF, and Merrick Garland in his official capacity as Attorney General of the United States, and Bernard G. Hansen in his official capacity, hereby move to dismiss pro se plaintiff Mark Jerome Johnson Blunt's complaint. Plaintiff seeks a declaration pursuant to the Declaratory Judgment Act, the National Firearms Act, the Gun Control Act, and the Firearm Owner Protection Act. Seeks that are unconstitutional as applied to plaintiff. Sorry, I got lost a bit in that block of citing acts. Gosney is headed over to have a meet and greet with Bronca. Tell Bronca I said hi. That's awesome. All right, so plaintiff's 491 paragraph complaint. They're going to keep mentioning that because it's hilarious. Contains only one factual allegation relevant to his claim, that plaintiff plans to purchase an M16 rifle, M4 rifle, squad automatic weapon, or other machine gun, or convert the AR-15 rifles that he already lawfully possesses to automatic weapons, and possess said weapons in the immediate future. Now, I'm wondering, what are the rules on mental illness, and owning firearms? Because this guy feels like there's some mental illness going on. The remainder of the complaint argues that federal firearms acts are unconstitutional as applied to plaintiff because plaintiff is a member of what he calls the posterity. This is what I meant by him being a very special boy, right? This is what I meant by him being a, he says that he's a member of the posterity, which means he's a very special boy. Which he defines as the direct lineal bloodline descendants of the founding generation of the United States. As a member of the posterity, plaintiff argues that he enjoys an ancestral right to keep and bear arms, which the founding generation did not have the power to regulate. It follows from plaintiff's argument that because the founding generation did not have the power to regulate plaintiff's ancestors' right to keep and bear arms, Congress today lacks the power to regulate plaintiff's right. The court should dismiss the complaint as to the federal defendants for lack of subject matter jurisdiction, or in the alternative, for failure to state a claim. Failure to state a claim basically means you are arguing a bunch of stuff and none of it is known to law. This is all crazy talk, and we're not gonna use it, or we're not gonna give it any merit here. So the term machine gun is defined to include any weapon that shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. And they also have, in a factual challenge, the movement relies on materials outside of the pleadings to contest subject matter jurisdiction. Osborne v. United States, McLean v. American Economy Insurance. So raising a factual challenge to the plaintiff standing to sue. In such cases, the court may rely on matters beyond the pleadings without turning the 12B1 motion into a Rule 56 summary judgment motion, and the non-moving party does not enjoy Rule 12B6's safeguards. All right, so decisional standard under the rules. The applicable decisional standard, that's a weird way of putting it, but they're basically saying, what is the legal test? Depends upon whether the movement makes a facial or factual challenge to subject matter jurisdiction. In a facial challenge, the movement argues that the allegations in the complaint are not sufficient to establish the subject matter jurisdiction. So basically, on its face, it is it's BS. In such cases, the court must afford the plaintiff the same protections as he would be entitled to receive under 12b6, i.e., that the court must accept all factual allegations in the complaint as true. Now, when I say that the court must accept them all as true, that does not mean that they are true for the trial. It just means that they're true for the purposes of this particular hearing, because they're not actually having a hearing on this issue at this point. They're just asking for it to be thrown out. Draw all inferences in the plaintiff's favor and grant the motion to dismiss only if the plaintiff fails to allege an element necessary for subject matter jurisdiction. So basically, we're giving every possible benefit to the plaintiff, and they're saying even giving him every benefit of the doubt, we should still throw this out. This motion to dismiss asserts a facial challenge to the court's subject matter jurisdiction. In ruling on a motion to dismiss for failure to state a claim, the court must view the allegations in the complaint liberally and in the light most favorable to the plaintiff. Now, keep in mind, this is a guy who cited Dred Scott. So the light most favorable to the plaintiff is still not going to be really good light. Additionally, the court must accept the allegations contained in the complaint as true and draw all reasonable inferences in favor of the non-moving party. To survive a 12b6 motion to dismiss, a complaint must do more than recite the bare elements of a cause of action. It must include enough facts to state a claim to relief that is plausible on its face. While a complaint does not need detailed factual allegations, a plaintiff must provide the grounds. Again, remember Brooks, grounds. He's actually got to provide grounds. The grounds of his entitlement with more than mere labels and conclusions or a formulaic recitation of the elements of a cause of action. What does that mean? He's got to actually lay out the basis for a claim. He can't just say, I have a claim because I say I have a claim. He's got to actually bring some facts. And yeah. All right. Discussion. For the reasons stated below, the federal defendants request that the court dismiss plaintiff's complaint for lack of subject matter jurisdiction, or, in the alternative, for failure to state a claim. As it is a threshold matter, the federal defendants' suggestions regarding subject matter jurisdiction are stated below. So, 1, they should dismiss for subject matter jurisdiction. To invoke the court's jurisdiction to decide a matter, a plaintiff must have standing to sue. So, standing. You can't just sue because you don't like a law. You have to actually be, you basically have to have some sort of skin in the game. You've got to have, a reason for it. And so what that means is, like, let's say I don't like the laws about jaywalking. I can't just go into court and say, I want to strike down the laws on jaywalking because I think they're bad laws. I actually have to have some connection to it. And so one of the easiest ways to get a connection to it is if I'm actually charged with jaywalking. So if they charge me with jaywalking, great. Now I've got standing. But let's say they don't actually want to charge me. Let's say I jaywalk in front of them 20 times and they just refuse to charge me. Well, then there's other ways to maybe do it. You have to actually be able to connect yourself to things in a meaningful way. So this requires a plaintiff to establish, to the manner and degree of evidence required at each successive stage of litigation, 1, an injury in fact. You have to actually be harmed by the law you want to be affected by. 2, a causal connection between the injury and the conduct complained of. So you can't just say I'm injured. It has to be as a result of the law you want to strike down. And 3, that the court is likely able to redress the plaintiff's injury. Now, this part usually isn't hard because usually you can redress the injury with things like money. Money solves a lot of problems. Somebody hurt your feelings. Money. if they hurt your feelings enough. Somebody broke your leg. We can't make them magically fix your leg, but we can make them pay you money. Somebody blew up your car. Money solves that too. Money is amazingly, like, money solves a lot of problems in court. Everything, you can't buy happiness, but you can put a value on it and then sue for it. So, in order to establish an injury in fact at the pleading stage, a plaintiff bears the burden to plead facts showing a concrete and particularized, actual or imminent. Imminent is a big is a thing here, because you don't actually, to challenge a law, you don't actually have to put yourself at legal risk. You can do so by being at imminent risk, but as opposed to a conjectural or hypothetical invasion of a legally protected interest. The standing inquiry is especially rigorous where reaching the merits of the dispute would force the court to decide whether an action taken by one of the other two branches of the federal government was unconstitutional. So he's got to have a real stake in this. Plaintiff's complaint contains a single factual allegation relevant to this complaint. Plaintiff plans on purchasing an M16 rifle, M4 rifle, squad automatic weapon, or other machine gun manufactured after 1987, or converting the AR-15 rifles that he already lawfully possesses to automatic weapons in the immediate future. Sorry about the cough. I'll try to mute when I can. So the law makes it illegal for any person to transfer or possess a machine gun. Yes, this is the bozo who talked about his LSAT scores. This is the government saying we want to throw his case out. So, unless the machine gun is possessed under the authority of a government or was lawfully possessed prior to May 19th, 1986, the date 9220 took effect. The National Firearms Act requires machine guns to be registered with the ATF and provides that applications to register a firearm shall be denied if the transfer, receipt, or possession of the firearm would place the transferee in violation of law. You know what they're doing right here? You know what they are doing? They are telling the court and also Mark Jerome Johnson Blount Esquire how easy it would have been to establish jurisdiction here. Here's how he does it. He goes and asks to buy a machine gun, asks to fill out the transfer, get the denial, and then challenge the denial. Really freaking easy. Super, super easy. Basic, easy stuff. Basic. So, because he failed to do the basic stuff here that any lawyer who has experience in this would have told him to do, they want to throw this out. Oh, I see we've got the EDB crew coming in. Hey, folks, it's good to have you. So this is basically, they're saying that what his efforts on this were pathetic. He really ought to have done better on this. This is essentially failing to do your basic homework. All right. Now, for the people who are just coming in, we are reviewing the government's response to Mark Jerome Johnson Blount Esquire, or Blunt Esquire. He is the lawyer who put his LSAT score into a filing, arguing that he is a very special boy, a member of the posterity, rather. He's more a member of the posterior, but anyway. And that therefore he should be allowed to have a machine gun. That's his argument. So the government is saying, nah, throw this out because he hasn't done his homework. Regarding plaintiff's claim seeking a declaratory judgment that restrictions on machine gun possession are unconstitutional and an injunction on their enforcement against him, plaintiff has failed to plead an imminent, concrete, and particularized injury. A plaintiff contesting the constitutionality of a criminal statute need not first expose himself to actual arrest or prosecution to be entitled to challenge the statute that he claims deters the exercise of his constitutional rights. But a plaintiff in a pre-enforcement constitutional challenge to a criminal statute may establish an injury in fact by alleging an intention to engage in a course of conduct arguably affected with a constitutional interest but prescribed by statute, and demonstrating that there exists a credible threat of prosecution thereunder. Again, this would be something that he could just that he could have just argued. He could have put in their affidavit. But, however, where plaintiffs do not claim that they've ever been threatened with prosecution, that a prosecution is likely, or even that a prosecution is remotely possible, they do not allege a dispute susceptible to a resolution by a federal court. I.e., you had to say this thing, you didn't say this thing, therefore your case gets thrown out. Yeah. So, I'm just trying to track. I see Stephen Gosney's got some questions, but I'm missing them in the chat. So, yeah. If you fail to plead certain things, you can end up with your lawsuit getting tossed. So, for example, let's say I go to McDonald's and I order a burger, and it turns out I get a Mr. Beast burger and it comes out raw and I get injured. Well, if I fail to say in my pleading that my injury was caused by eating that burger, then they're going to throw my case out for failing to properly plead a case. It's, you might think it was obvious, but it's a thing. You got to do this right. This is a good reason why you're asking, why you might get a lawyer. Persons having no fears of prosecution except those that are imaginary or speculative are not to be accepted as appropriate plaintiffs in such cases. Yeah. Is he this type of law student who would be called a gunner? I don't know, because a gunner typically refers to somebody who's like annoyingly aggressively trying to get good marks, and who is somebody who's like always asking questions in class to show off how smart they are, that kind of thing. I don't know if that was something he was doing in this circumstance. I don't know if that was something that he was up to. But, yeah, I just think that he's largely more just annoying. I think he's just... I don't think he was likely to be well liked by his peers, but that's its own thing. All right. Susan Davidson. I'm not sure what you're asking me for about more collab between UK and USA. I don't know what you're asking me for. I've seen several chats on this, but I just don't know what you're requesting. Yes, this is the genius who cited Dred Scott in his lawsuit. So, plaintiff merely alleges a general intent to violate the law by purchasing a machine gun or converting an AR. Plaintiff thus fails to allege anything beyond a speculative fear of prosecution. Such someday intentions, without any description of concrete plans, or indeed any specification of when the someday will be, do not support a finding of actual or imminent injury. And they cite some case law. Plaintiff's assertion that they wish or intend to engage in prescribed conduct is not sufficient to establish an injury in fact. So basically, he had to say something like, we need to buy this, like he needs to be inclined to buy this right away. He's got to say when he would buy this and that he's going to be affected. Without more, plaintiff's complaint is merely a generalized grievance on an issue of wide public significance, namely the existence of the law. So plaintiff's remedy, therefore, lies in the political branches, not the judiciary. I.e., if you want a machine gun, go talk to your politicritter and get them to legalize buying a machine gun. Write a letter to Joe Biden and say, I want a machine gun, and make it 189 pages. And maybe not that last part. So, all right. Now, I'm, what is that? I don't own a barrister's wig, but I should see about trying to get one. All right. I'll try to watch for you in the chat there, Steve, because that's, yeah. All right. So just because plaintiff does not like the firearm regulation does not give him standing to complain about its legality. And the thing is that as much as I'm in favor of people challenging the government over this kind of thing, I don't want this guy doing it. I want somebody sane doing it. So, all right. So that's basically the first argument here. They note that last month, a district court in Wyoming dismissed a Second Amendment challenge because the plaintiff had failed to allege a sufficiently concrete intention to acquire a machine gun. This keeps going for a bit. We're going to skip over a little bit. Alternatively, the court should dismiss the plaintiff's complaint for failure to state a claim, as machine gun ownership is not protected by the Second Amendment. So this is a legal argument. They're saying that the Second Amendment doesn't protect machine guns. And this is why I hate this guy, because he actually may end up getting a ruling from the court that says that the Second Amendment doesn't apply to machine guns, because this guy is crazy. And the court is not, there is no world where the court is going to side with this guy. Mark Jerome Johnson Blunt Esquire is not going to win. There is no way that he wins, but he can lose in ways that hurt other arguments and other claims that other people might want to make. So they say in the United States and Miller or v. Miller, the Supreme Court limited the types of weapons protected by the Second Amendment. And that was with regards to short-barreled shotguns. They also noted that in Heller, Heller said that the Second Amendment conferred an individual right to keep and bear arms, but acknowledged that the right was not unlimited. And what is that? Heller rejected a reading of Miller that the Second Amendment protected weapons useful in warfare, noting that this reading would lead to the startling result that the National Firearms Act's restrictions on machine guns, not challenged in Miller, might be unconstitutional, machine guns being useful in warfare in 1939. So the court thus found it so clear that the NFA's regulations on machine guns were constitutional that it curtly dismissed the contrary notion as startling. I'm going to skip over the rest of this argument because they basically are going over this, and I think that this deserves more looking at, but not in this stream. I want to get on to some other stuff on this one. But suffice to say, if you like Mark Jerome Johnson Blunt's argument, in the sense of you like the idea that that he should be able to have machine guns, then you hate him bringing this claim, because the court could very well side with the government here and say, yes, we agree that the Second Amendment does not protect machine guns, and that ends up being case law that hurts everybody. I see somebody was suggesting that I should reach out to Fudbusters. That's not a bad idea. I don't know if he'd be interested, but it's that it'd be worth looking at. All right. They have a third argument, which is just more subject matter jurisdiction or failure to state a claim. But this is just basically a document referring to the other documents. So I just wanted to give everybody that heads up, because I've had some people asking me like, hey, what's happening with the crazy LSAT lawyer? And as it turns out, the crazy LSAT lawyer is still crazy LSAT lawyering out there. And yeah. Now, I will note, this was sent to me sort of on the back end. Mark Jerome Johnson Blunt paid some money to file this. Specifically, it cost him $402 to file this. So he's out some money. I don't think he's getting that back. And I think this is a good comment here. Al Fliggins notes, I'm okay with responsible gun owners having machine guns. I'm not okay with this guy having any guns. I went and shot at a range with Donut Operator and Brandon Herrera, who's now running for Congress, apparently. So um, and while I was there, I shot a bunch of machine guns, quite a few, in fact. Um, that was people behaving very responsibly with them. Everyone was very careful. Everyone was making sure shots are going into the berm. All of that was, people were just being super cautious, super careful. Everything was great. But I don't like the notion of this guy having anything because, yeah, that's concerning. All right. Now I wanted to go and look at Mr. Oher. Now I don't know Oher at all. Oher, he's like apparently a football player. Now I can tell you, if you add up all of the if you add up all of the football I've watched in my life, and you took that time and you ordered a pizza, the pizza would probably take longer to reach me than all of the football I've watched over time. Oh, and I'm being told I got to swoop. So swoop. All right, and I'm being told it's pronounced or. So that tells you just how much I've been watching this and watching sports. Somebody's saying, does that include soccer? I used to play soccer as a kid. I sucked. Like, let's be clear, I sucked. But so he was featured in a movie called The Blind Side, I think it was. And so the background on this is that he was supposedly adopted out of miserable, like, poverty by a wealthy white family. And so this ends up being, they make this into a movie. That movie won Oscars, apparently. And that was a big deal. They've been, and so his supposed adoptive parents, who aren't adoptive parents, we'll talk about that, have been using this story to go around and become motivational speakers, to start a foundation, to do all sorts of things, and to get speaking money and so forth. So this is the guy the movie was based off of. So he is he's a retired football player. So he did a whole bunch of really impressive, he's an impressive guy. But he is now petitioning to the court about this in a way that is surprising to a lot of people. Because apparently, and again, I didn't watch the video. I've never watched The Blind Side. I'm probably not gonna. I guess I might have to if I still have to talk about this. But if we end up sort of covering this in detail, I guess I'll have to watch it. But he's saying that basically this movie was a fiction, that this was a fantasy sold to the world that was never really true, and that in fact he was deceived, and that other people were deceived in the process. So I'm gonna go and I'm gonna first let's get some super chats covered, just so I don't get too backed up here. So I see Alan Fortenberry was saying, I'm looking at reading Terry Pratchett. Any recommendations? There's all sorts of guides for like reading order. I also really like going postal. So if you start with that, it's not a bad choice. Neurotic Nettie had a rough couple of months. Thank you for being. I hope you're doing all right, Neurotic Nettie. That's I hope you're doing all right. Alicia G, hope you'll have a great week drinking watermelon cider. Ooh, neat. I'm still trying to shake this whatever it is that's in my lungs, but Here's hoping it gets better. Caitlin Moore sending everyone love today. Thank you for the space, Runkle. Thank you. Woot, Runkle time. Thanks for doing Monday Fun Day. I'm always enjoy it. Casey Cat, thank you for the new YouTube membership there. Much appreciated. Susan Davidson, Ian, you and Andrew Gold would be gold. Please, especially regarding your cases now. I'll have to reach out. I'm just making a note here. So, Andrew. Oops. Gold. All right. I'll look into that as we go. Nicholas Starro says, I am Nick. My IQ is 3 digits. Now you must obey. 100 then. Canonical Heat says, my ancestry gives me special rights to a sword. I have 2. I'd like to introduce this guy to them. Let's not introduce anybody to any swords, but I got 2 swords and some other kukris. I should buy more swords. So your take on sidelines is fantastic. Well, thank you. You need to do a sesh with Andrew Gold, mister. I will look into that. Why not involve your UK viewers sometimes? I'm not sure what that means. So, yeah. Summer Butterfly, thank you for the membership. Much appreciated. Do you think a North American Union would be good? Oh, that's a political topic and a half. I don't know that I could cover that one in sort of limited time here. Complicated, I guess, is the issue. So, and I don't think Canada would have a whole lot of say in such a union. So, yeah. More or less annoying than the stalker lawyer. Oh, God. This guy and stalker lawyer should start a firm together. And then, like, yeah. Lori Linney, thank you very much for the YouTube membership. Much appreciated. And Time, thank you very much for the super sticker. All right, so let's keep going here. All right. So we'll just have a look. Let me just bring up this case here. And yes, this is a conservatorship case. Now you might be wondering, why would this be? Why would he be bringing this now? Well, I think that there's a lot more interest overall being brought in on conservatorships. Conservatorships. Oh, right. I'm missing the memberships. Sorry. Somebody in the chat is saying, hey, don't forget the memberships. Tony P, thank you very much for 5 gifted memberships. Canonical Heat, thank you for 20 gifted memberships. Angie Torres, thank you for 10 gifted memberships. And Canonical Heat, thank you for another 20 gifted memberships. Much appreciated. Sandra D, thank you for 5 gifted memberships. Jill Higgins, thank you for 5 gifted memberships. Fiona W, thank you for 10 gifted memberships. Casey Cat, thank you for 10 gifted memberships. And Pants, thank you for 5 gifted memberships. Much appreciated. Handmaid Darcy, also thank you for your membership. So, what is a conservatorship? Well, a conservatorship is it's a legal way of essentially helping somebody who is who might not be able to help themselves in various ways. So let's say, for example, you've got somebody with profound mental health issues and they cannot manage their own affairs. As an example, you might have somebody who's got, I've heard of conservatorships being applied for people who have, for instance, like cycling mood disorders, where they have manic phases. And the reason why a conservatorship might be appropriate in those circumstances is that they might have a tendency to completely destroy their financial existence every time they're in a manic phase. You might have somebody who's wildly schizophrenic, and they might have money. They might be somebody who's wealthy. They might be somebody who, like, let's say they've inherited $1 billion. And then after they've got this $1 billion, they develop schizophrenia. They can't manage their own affairs. So you might have a family member who steps in to be a conservator to make sure that that money is protected, and to make sure that it's used for the benefit of the person, so that they can then turn around and use that to to help that person. The problem is that conservatorships have a dark side. There is abuses of conservatorship, where conservatorships um, give you a lot of financial or other control over over other people, and so there can be an incentive to get a conservatorship over somebody who might, uh, like, let's say you've got that person with the $1 billion. Well, you go and you get that conservatorship, and then you turn around and spend that $1 billion on yourself. That's a problem, right? And it happens. The other thing that happens is you get people who are entered into a conservatorship that maybe isn't justified, or maybe was justified, but instead of ending when it should have ended, it continues indefinitely. This is most famously what we saw with, or what was alleged with Britney Spears. Britney Spears had some mental health issues um, at one point, and she was roundly mocked for her mental health issues, which does not feel like that didn't age well at all. Um, but um, she was held in this conservatorship long after she didn't want to be, and appeared entirely capable of managing her affairs. And while she was in that conservatorship, it looks like, I mean, the allegations were that her conservators were doing great financially. So this is sort of the allegations around the Britney Spears aspect. And because Britney Spears has raised a lot of attention about this, we've actually seen things like politicians getting interested in this and looking at changing the laws and so forth. So this is kind of important background, because conservatorship has all sorts of, creates all sorts of power over someone's life. And we're going to see that in this case. Now, I had a little moment of terror because I was thinking Mark Jerome Johnson Blunt, and I saw Michael Jerome, and I went, oh, God, I'm looking at the wrong case. No, they just happen to share a middle name. So, you might be wondering why they've got Michael Jerome Williams Jr., a.k.a. Michael Jerome Orr. He changed his name. He was originally Michael Jerome Williams. And so the reason why he's mentioning that in his pleadings is so that when there's documents that show the Williams name, that the court knows who's being talked about. That's really what that's about. All right. So, petition to terminate conservatorship for accounting and other relief. So he wants three things. One, he wants to end the conservatorship. He wants to be free of that. Two, he wants an accounting of all the money that was involved in the conservatorship. Who got paid? How much? When did they get paid? From where? All of those things. He wants all of that stuff. And the third is other relief. What is the other relief? Well, I talked about this before. What solves all problems in court? Money solves all problems. He wants money. He wants to get paid. He's basically saying, listen, I was screwed out of a bunch of money. Pay me. Pay me back for all this money that you took from me. So, or that you earned writing on my name improperly. That's what he's asking for here. Now, again, all of this is allegations at this point. It's important to note, this is Michael Orr's story. We haven't heard the other side of the story. We're going to hear it. There's going to be a response filed, because I can tell you, these filings, there's definitely going to be a response filed. But, and I don't know if chat has frozen or if just nobody is Nobody's talking. But so it begins in my favorite line. Comes now. It's always comes now. Michael Jerome Orr, personally and through the undersigned counsel, so through his lawyers, and petitions the probate court for an order for a final accounting in the above referenced cause to close the conservatorship, for an order requiring the co-conservators Sean Toy. I'm not sure how to pronounce that. Chat, how do I pronounce that? Or I guess chat's frozen. That's weird. Oh, I can see my own chat. I don't know if anyone else can see anything, but so hopefully you guys can still see me. So I'm just checking with some of the people on the back end on that, but I don't know how Toy is pronounced here. And Leanne Toy to show failure to meet the required duties and to provide regular accountings. Oh, chat just moved all at once. All right. So guys, it just scrolled by like 1,000 chats. So if you said something, I missed it. I see people saying Tui. Okay, so Sean Tui and Leanne Tui. I understand that Sean Tui is also a sports ball announcer. So, all right. So, so for failure to meet the required duties to provide regular accountings or to act in the best interests of their ward, Michael J. Orr, and for applicable damages and other relief. In support thereof, petitioner Orr states unto this court. Now, we're going to, we're going to see what's being said here. But before we do that, I'm going to bring up something else. I'm going to bring up the conservatorship order. We're going to pause to have a look at the conservatorship order because we want to know what we're actually talking about. So, in the probate court of Shelby County, Tennessee, order appointing conservators of the person. So, this cause came to be heard upon the sworn petition of Sean A. Tui and his wife Leanne Tui for the appointment of a conservator of the person of Michael Jerome Williams Jr., also known as Michael Jerome Orr, hereinafter referred to as Orr, and upon the sworn testimony of Sean A. Tui and his wife Leanne Tui, Denise Orr, and Michael Jerome Williams Jr., aka Michael Jerome Orr, from all of which it appears to the court as follows. The petitioners, Sean A. Tui and his wife Leanne Tui, reside at... Sorry, I got these directly from Pacer. So this is filed publicly, but it's an address. I'm not going to read it out. They have resided at the residence for more than 1 year, next preceding the filing of this petition. It further appears to the court that the petition is joined in by Orr, who is an 18-year-old male resident in Memphis, Shelby County, Tennessee, born May 26, 1986, and who currently resides at the same address. It further appears to the court that the natural mother of Michael Jerome Williams Jr. is Denise Orr. It further appears to the court that Denise Orr joins in this petition. Ms. Orr currently resides at address. It further appears to this court that the natural father of Michael Jerome Williams Jr. was Michael Jerome Williams Sr. of Memphis, who died in 2004. So, yeah. It further appears to the court that there are no persons not a party of the above styled and numbered cause who have physical custody of said or who claim to have custody or visitation rights with respect to said individual. I.e., there's no other person that is connected to this who might have custody. The reason why that's important is that you don't want a conservatorship to basically steal a kid. Yeah. None of the parties to this action have participated as a party, witness, or in any other capacity in any other litigation concerning custody or conservatorship of the said or. Further, petitioners have no information about custody or about any other proceeding pending in any other court. It further appears to the court that the said or though having reached the age of 18, is enrolled in high school for the coming year and is scheduled to graduate in May 2005. It further appears to the court that it is Ower's desire that the petitioners be recognized as his conservators until terminated by an order of this court. It further appears to the court that petitioners have provided and will continue to provide assistance and guidance as necessary. It further appears to the court that the petitioners and the said Ower have enjoyed a close and familial relationship for many years, and further that the said Ower has lived in the home of the petitioners and wishes to continue to do so. It further appears to the court that it is in the best interests of the said Ower that the petitioners be appointed as his conservators of the person. It further appears to the court, oh, that's going to be annoying, that Ower has no estate, and further that he is dependent upon the petitioners for his support and financial needs. So that's going to be the basis for this conservatorship there. It further appears to the court that petitioners have sought no support or assistance from any agency for the financial needs of Ower and are financially able to provide for him. It further appears to the court that Ower resides in the home of the petitioners along with the petitioners' natural children. It further appears to the court that Ower has no known physical or psychological disabilities. So he's not got any mental health issues at this point. He's not got any issues in terms of physical disabilities or the like. Court also says that it's in Ower's best interest to appoint Sean A. Toohey and his wife Leanne Toohey as conservators of the person, and that they should have all powers of attorney to act on his behalf. And further, that Ower shall not be allowed to enter into any contracts or bind himself without the direct approval of his conservators. So let's talk about power of attorney. Power of attorney is an incredible power. And power of attorney is one of the ways that as a lawyer you can really screw up. Because one of the things you'll get people doing is they'll come to you and they'll say, I want to sign a power of attorney. And basically what I have to do is, in that situation is go, whoa, 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 whoa. Slow your roll. Do you know what you're signing here? Because if you are signing a power of attorney, you're basically signing your life away. You are signing away all the power to act as you. Now, you might think, oh, who cares? I don't do anything important anyway, so who cares if somebody is going to sign as me? So, let's talk about the things you can do with that. You can empty out all the bank accounts. That is sort of only the beginning, because you can also end up, taking money that the person hasn't even made yet, and in fact may never make. So what I mean by that is that you can go and take out a loan in somebody's name. If I have power of attorney over, I don't know, Britton Campbell, I'm just picking this person out of my chat just because. I could go to the bank and say, I would like a bank loan under Rin Campbell's name, and I would like it for as much money as you will possibly give Rin Campbell. No, I will not co-sign this bank loan. I will have no obligation under this bank loan. This bank loan entirely belongs to Rin Campbell. You can get all sorts of power with it. The reason why this comes up as issues is that power of attorney comes up sometimes because people are going to jail. The reason why it comes up is that people are in jail and they need somebody on the outside. Like, let's say I've got a house, right? And I've got a, and I live alone. Like, let's say my wife let's say I'd never married, right? But I have a house. And let's say I was going to go to jail for a year, right? I want my house payments to continue to be made. I would want my mortgage payments to continue to be made. I would want somebody to be hired to check on the place to make sure it was okay, to go in and mow the lawn, to to do all those things, right? Take care of my affairs. And so I might want a power of attorney to do those things. That way they have the power to use my money for those kinds of things. And there's all sorts of good reasons for a power of attorney. For example, if I if I have a stroke and I'm still alive, but I'm mentally incapacitated, I'm completely unconscious, I can't do anything, right? My wife would get power of attorney in that circumstance, and she'd have, the ability, medical power of attorney to make medical decisions, but also probably financial power of attorney to do that sort of thing. So power of attorney gives you all sorts of crazy powers. People abuse power of attorney all the time. So you warn people, listen, if you, you might have good reasons to sign this, but let's go over that. And let's make sure that you actually know what you're signing. Like, let's make sure that you are aware of, let's make sure you're aware of it before you do it. Because otherwise you can be in big trouble. But you can sign contracts on somebody else's behalf. You can sign all sorts of things. It basically lets you step into that person's shoes. So, they got power of attorney out of this. Also, or is banned from entering into any contracts on his own or binding himself without the direct approval of his conservators. I just want to say, this is crazy, because you enter into contracts all the time. All the time. So, let's talk about some contracts you might be in right now. If you have a mortgage, you have a contract. If you have a rental agreement, like you live in an apartment, then you have a contract. If you have a cell phone, you have a contract with the cell phone company. And when I say you have a contract with the cell phone company, I mean, like, even if you don't think you're on a contract, you're like, oh, I don't have a contract, I'm month to month. Well, month to month is actually still a contract. It's just not a contract that requires you to be on a particular term. You want to eat at a restaurant, you have a contract. When I sit down at a restaurant, I look over the menu and I say, I would like a steak, and I'd like it rare, and I'd like a whiskey with it, please. Please bring me those things. I've just formed a contract with the restaurant. I am going to be given a steak and a whiskey, and in exchange, they are going to be given money. They're going to be given money. So, now this guy went on and he played for, like, the NFL. How the heck does that happen if he's not allowed to form contracts? Because, yeah. So many other things. Now, here's the other one. It further appears to the court that any and all medical decisions shall be made by the conservators, who will have full and complete authority to make these decisions and educational decisions in Orr's behalf. So according to this conservatorship, he's not allowed to go to the doctor without permission. He's not allowed to have surgery. Like, if he injured himself out there and needed surgery, all of this is crazy to apply to an adult. Like, keep in mind, we're talking about an adult with no mental or psychological disabilities. Why did the court not go, what the hell? What the actual hell? It further appears to the court that the petitioners should have complete and full access to all medical and school records as if they were the natural parents and guardians of Ower. Okay, there's a better way to do that. So, it is therefore ordered, a judge and decreed that the petitioners, Sean A. Toohey and his wife, Leanne Toohey, be and are hereby appointed as the conservators of the person of Michael Jerome Williams Jr., also known as Michael Jerome Ower. Further ordered and adjudged and decreed that the necessity of posting bond be waived, and that the cost of this cause be adjudged against the petitioners, for which let execution issue. I.e., they got to pay the cost of getting all this done. All right. So that's one thing. We're also going to look at something else. That's this. So we're just, keep in mind, we're paused on all of this. So in the probate court of, and I'm just looking at one thing here. Sorry, I'm just trying to pull up something as I look over this. All right, so we've got order waiving appointment of guardian ad litem. So there doesn't need to be a guardian on that. So he doesn't have that protection either. All right. Yeah. Let's have a look back at the actual document itself. All right. So introduction and factual background. Michael Jerome Ower, hereinafter petitioner, or Michael, now age 37, grew up in Memphis, Shelby County, Tennessee, in the Hurt Village housing projects north of St. Jude Children's Research Hospital. Michael was one of 12 children born to his mother, Denise Ower. That's rough. On April 14th, 1996, when Michael was not quite 11 years old, his custody was awarded to the Tennessee Department of Human Services, in whose legal care and control he would remain until becoming an adult. As a ward of the foster care system, DHS did little to help Michael. So this is also an indictment of the system here. So this is also an indictment of our whole the whole sort of process for all of that. Now I kind of skipped over the guardian ad litem there. And that is a person who is there, who acts in the best interests of the child. So a person there who is to represent the interests of the child. That normally would be something that you'd want there, but that was not actually, he was not given that protection. And we'll talk about that because I think that there was counsel involved on all of this. So this story, by the way, is going to be really tragic. This story makes my heart hurt. It's bad. So the representatives of DHS tasked with caring for Michael ultimately lost track of him in a broken social system, leaving Michael to live on the streets, taking care of himself as best he could. Michael was a smart child, but his formal education was spotty to non-existent. He attended 11 schools in 9 years, repeating first and second grade. In the movie, I understand that they said that he couldn't read. I also understand that that's false. But still, he didn't get a great education here. In the late summer of 2002, a kind man named Toby Henderson, the father of a friend of Michael's, witnessing firsthand Michael's focus and drive to pursue a better life, took it upon himself to find a school that would agree to provide Michael with a decent education. Mr. Henderson introduced Michael to the principal of Briarcrest Christian School, Dr. Stephen Simpson, who recognized Michael's potential in their first meeting and, along with other administrators at Briarcrest, agreed to provide him the life-changing opportunity of an education at their school. This is a really, this is a really heartwarming story here. Briarcrest agreed to admit Michael as a student, and upon receiving satisfactory grades, allowed him to participate in their sports programs. Now, when the movie says that he's not listed as being like that he's unable to read, how do you think he's receiving satisfactory grades in school if he can't read? I don't think that's the case. Sorry. All right, sorry about that. In September 2003, Michael's junior year, Michael began playing sports at Briarcrest. From the beginning, he excelled. He made first string for the Tennessee All-State game in both football and basketball and was selected to play in the Army All-American Bowl his senior year of football. So already he's, you can see he's got some great talent there. It was clear that Michael had the size, speed, physical ability, and mental acuity to be a star in college and afterwards. Football scholarship offers poured in from the powerhouse football universities across the nation. All right. Michael was on his own at Briarcrest and nearly penniless. It took over an hour riding buses and walking to get from Hurt Village to Briarcrest. During his 10th and 11th grade years at Briarcrest, Michael often stayed at the home of the grandfather of his friend, Quintario Franklin, and he had other benefactors as well. He often stayed overnight at the homes of classmates whose parents saw Michael simply as an intelligent, polite young man who needed the basic support that no person, agency, or other social system had been able to provide Michael for most of his childhood. And it's kind of heartwarming that people were rallying around this guy. So during the summer after his junior year at Briarcrest, Michael also occasionally stayed with Sean and Leanne Toohey. Where other patients of Michael's classmates saw Michael simply as a nice kid in need, conservators Sean Toohey and Leanne Toohey saw something else. Now, this might be a little overwrought, and I'm just going to tell you that right now, but that's the language of lawsuits. A gullible young man whose athletic talent could be exploited for their own benefit. The Tooheys, who took no legal action in juvenile court to assume legal custody of Michael, a ward of the state, began inviting him to their large, beautiful home more and more often during that summer. Miss Toohey began taking Michael on shopping trips, buying him clothes. In July of 2004, after Michael became an adult but still enrolled as a student at Briarcrest and just before his senior years, the Tooheys invited Michael to come and live with them. At no time prior to this invitation during Michael's minority did the Tooheys take any legal action to assume custody of Michael from DHS through appropriate channels, nor did they seek to become Michael's guardian while he was a minor. And I'll talk about why that might be. Despite this inaction, the Tooheys did tell Michael they loved him and that they intended to legally adopt him. Michael believed them, was delighted to be part of a real and stable family, and trusted Mr. and Mrs. Toohey completely. The Tooheys encouraged Michael to refer to them as Mom and Dad, and Michael happily complied. Almost immediately after Michael moved in, the Tooheys presented him with what he understood to be legal papers that were a necessary step in the adoption process. Okay, let's talk a little bit about this. Why would they not have started this while he was a minor? Well, if they did this while he was a minor, and I'm not saying that this was their reasons, but it certainly seems suspicious. Had they acted while he was a minor, the court would have stepped in to say he needs independent counsel. He needs to have he needs somebody representing his interests. He needs somebody to make sure that he's going to be okay at the end of this. But once he's a minor, or once he's not a minor, then a lot of that requirement goes away. So, so he thinks he's signing adoption papers. What he's actually signing, however, unknown to Michael until after February of 2023, that's a long time to figure this out, were not adoption papers or the equivalent of adoption papers. Instead, it was the petition for appointment of conservators, which was filed in this cause on August 9th, 2004, by Deborah Brannon, attorney of record in this matter. Miss Brannon was so close to the Toohey family that Michael was encouraged to refer to her as Aunt Debbie. So they have one lawyer, but it's not his lawyer. He doesn't have a lawyer representing his interests. Now, let's take a little break. And when I say a little break, we're going to look at another little. We're going to look at a web page, and in fact, we're going to look at a couple of web pages here, because I want to talk a little bit about the Tooheys and the stuff they get up to. So let's talk about motivations. And again, this is going to be sad. So this is Leanne Toohey's webpage. And you can see she's got pictures of her. She's all over the world. She's having a great life here. She's doing all sorts of things. Families, all of these things. There are pages and pages of this. I'm just going to see if I can pull up another page. Oh, it won't pull up. About. So we can see, she's got a big page about herself here, talking about all of this, about meet my family. So she's still got Mr. Tour or Mr. Orr, listed there. She's got right there, learn more about Michael. So there's, Michael Orr's picture is still up on their webpage. So Michael Orr's inspirational journey from the streets of Memphis to the NFL was chronicled in Michael Lewis's best-selling book, The Blind Side, now a major Hollywood blockbuster. So they've got his biography up there, which he's not a big fan of. You can go shopping on their page. So they've got their families don't have to match shirts. They got In a Heartbeat, their book. They've got their turnaround book. They got all of this stuff. Property of the Blind Side athletic department. So you can see that they've got some real stuff, going over on that. Now they also have philanthropy listed at the bottom. So philanthropy is where this gets. Yes, and the Tooheys were independently wealthy way before meeting Orr, but that still doesn't mean that this isn't kind of gross. Because they may have been independently wealthy, but this gets them like a charitable thing going on. Let's look at the Making It Happen Foundation. So you got the stock photo of the child. I assume that's a stock photo. You've got the About Us picture that, where back when Michael Orr was still, keen on this. You've got all these pictures of them going around doing all this charitable stuff. Now, I'm really curious to see how much people are getting paid. Because board of directors, Sean Toohey, Leanne Toohey, Collins Toohey Smith, S.J. Toohey. So the whole family is listed there. But I just wanted to point out the other person who is listed on the Making It Happen Foundation. That's Debbie Brannon. Aunt Debbie. That's, this is worrying when she's involved in this operation. And it's quite a career switch to move from like family law to running a foundation. That is quite an interesting career switch. Angel, I say, Ian, you're showing bias without all the facts. No, I'm talking about the facts as they've been alleged right now. We don't know what we're going to see the other side's argument later. We're going to have a look at it. But right now, I'm looking at what we've got. And somebody says, no, Michael. Yeah, no, Michael's not in this loop. Um, but I mean, he's got his own, his own career there. But yeah, it's this is concerning, and I'm really concerned about um, you know, about what's going on. Um, I want to hear I want to hear Debbie Brennan's take on this. I want to hear on all of this because I have some real concerns as to what she was like, what was going on here. These allegations do not make Debbie Brennan look good. And quite frankly, if these allegations are, are upheld, who? So, yeah, Debbie Brennan, who is now the attorney for the foundation, was also the attorney on this particular claim. So that just makes me all sorts of worrying as to what's happening on this. All right, let's go back. So this petition, filed on behalf of the Tuohys, Michael and his mother, Denise Orr, by Ms. Brannon, as the attorney of record for all four petitioners, which would not be attorney of record for, or one, two. Yeah, I guess she would be the attorney of record for Michael at that point. And so if she's the attorney of record for Michael at that point, then she was his lawyer too and had an ethical obligation to him. So I think there's some concerns on that one. I want to see her response. I'm wondering, is she going to end up named in a lawsuit? Is she going to end up named in a complaint? Because I have questions. So, included a request that the conservators has total control over Michael Orr's ability to negotiate for or enter any contract, despite the fact he was over 18 years of age and had no diagnosed physical or psychological disabilities. The August 9th, 2004 petition states in pertinent part that the said Michael Jerome Williams Jr. shall not be allowed to enter into any contracts or bind himself without the direct approval of his guardians/conservators. Oof. All right, we read the rest of it already, so we're not going to go through all of it. But at no point did the Tuohys inform Michael that they would have ultimate control of all of his contracts. And as a result, Michael did not understand that if the conservatorship was granted, he was signing away his right to contract for himself, which again is a tremendous thing, right? That you agree to contracts all the time without realizing it. Contracts are just so ubiquitous. When you go to a web page and it comes up with terms of service, you're signing a contract. I just bought a Steam game yesterday. Contract. All of these are, contracts. Michael was falsely advised by the Tuohys that because he was over the age of 18, that the legal action to adopt Michael would have to be called a conservatorship, but it was, for all intents and purposes, an adoption. Now, here's the thing. You can do an adult adoption. That's a thing. You can do an adult adoption. And he didn't. They didn't adopt him. And they've told the world, right, in these various, books and movies and so forth, they've said, hey, that we adopted Michael, but they didn't do that. And his lawyer would have known, or should have known. How would his lawyer not know that a conservatorship is not an adoption? I just don't see how that could have been the case. So the Tuohys have falsely and publicly represented themselves as the adoptive parents of Michael, continuing to the date of the filing of this petition, See, for example, the Toohey family website. We just checked that out. It's still up there. Still up there. And their foundation's website, where Michael's name and likeness is used to benefit the Toohey's interests and where Michael is claimed to be adopted. Such false and public misrepresentations have caused irreparable injury, loss, and damage to Michael Oher, and unless the conservators are restrained and enjoined from continuing to make such misrepresentations, will continue to cause further injury and damages. The lie of Michael's adoption is one upon which co-conservatives Leanne Toohey and Sean Toohey have enriched themselves at the expense of their ward, the undersigned Michael Oher. Michael Oher discovered this lie to his chagrin and embarrassment in February of 2023 when he learned that the conservatorship to which he consented on the basis that doing so would make him a member of the Toohey family, in fact provided him no familial relationship with the Tooheys. So, the Tooheys had huge money, right? Huge money. And if he's not actually adopted, for instance, he's got no claim to, if people die, he's got no claim. And somebody's saying they were his guardians. I don't think they ever said that that they adopted him. Well, I'm just gonna quote from their webpage here, and we'll just pull that up again. Just pull up the webpage. Michael, the adopted son of Sean and Leanne Toohey. Michael spent most of his childhood in foster homes and moved in with the Tooheys when he was 16. I'm just going to embiggen as big as we can. The adopted son. Says right there, big freaking letters, because I embiggened. That's on the webpage right now, today. It's August 14th. So they've told the world for sure that he is the adopted son, but they never actually adopted him. Like, can you imagine finding that out? Can you imagine being like the turmoil that he would be going through to find out that he thought he was adopted and he never was? Can you imagine the feelings of betrayal to know that? Like, you're on this page as the adopted son, but he's got no actual rights. So, the people he thought were his adopted parents, for example, if they got sick, if they got into a car, like if they got into a car accident and were in the hospital, and he walked in and said, I'm their son, and anybody checked the legal paperwork, they would determine that, in fact, he was not the son. He was not adopted. He has no legal standing in that regard. So, freaking tragic. In August 2005, Michael entered the University of Mississippi on a football scholarship at the age of 19. During his first year at Ole Miss, Michael earned freshman All-American honors. He also excelled in the classroom and made the dean's list academically his sophomore year. On September 2nd, 2006, Blindside, The Evolution of the Game by Michael Lewis, a book based upon the life of Michael Oher, was released. And there's a little footnote here. Important footnote. Footnote number 2. Michael Lewis is the childhood friend of Sean Toohey. Shortly thereafter, conservators begin contract negotiations with 20th Century Fox regarding their personal rights and the rights of their then minor children, Sean Toohey Jr. and Collins Toohey, to a movie based upon the Blindside, it's a typo there, Evolution of a Game. Upon information and belief, the Tooheys used their status as conservators for Michael Oher to negotiate a contract with Fox for the movie The Blind Side, based on Michael's life story. Interestingly, Section 18, titled Notices and Payments, of all four of the Tooheys' family members' contracts with 20th Century Fox lists Matthew Snyder at Creative Arts Agency as the Tui's contact. But the agent attorney to receive contract and payment notices for Michael is listed as Debbie Brennan Esquire, the attorney of record in this matter. Wow, Debbie Brennan Esquire does entertainment law too. Family law, entertainment law, charity law. She does it all. She's like the Swiss Army knife of lawyers. Got some thoughts. Got some opinions. Maybe a few more drinks and I'll share them. We got 20 more minutes before I'm going to share some of them. Oh, yeah. I got some big questions for Debbie Brennan Esquire. Big questions. Upon information and belief, conservators negotiated for themselves and natural-born children You see that? They negotiate for themselves. Like the allegation here, and again, these are allegations, but the allegation is that they negotiate for themselves and for the natural-born children, i.e. not him, a contract price of $225,000 plus 2.5% of all future defined net proceeds. All payments were contingent upon Fox first acquiring Michael's signature. Upon information and belief, the Blindside movie has amassed gross revenues of more than $330 million and still earns large sums of money. Now, I'm just going to say, that 2.5% is worth nothing. They got screwed. And I could tell you, like, I'm going to reach out to the Hollywood attorney on this one. I've been wanting to do a collab with her for a while. I'm going to see if I can bring her on to talk about this one. The saying is basically only idiots take net. And the reason why is that Hollywood accounting means the net will be nothing, will be negative. Cynical Girl, we'll get to he signed the contract and agreed. We'll get to that because we'll get to the allegations there. But the $330 million gross, I can tell you that when you get to the accounting, when you get to the net on that, and I mean, I don't know if the Hollywood attorney will agree, but I want to try to bring that on or bring her on to talk about this one. I don't know if she can. Maybe she worked for Fox. But I can guarantee you that the net on this one will show as like zero. So that 2.5 of all future defined net proceeds, I bet they couldn't buy a cup of coffee with that. Now I get why he might think it's a lot of money. Lots of people think it's a lot of money. But yeah. All right. A contract also exists entitled Life Story Rights Agreement, purportedly signed by Michael Oher, dated April 20th, 2007, in which the subject, Michael Oher, appears to give away to Fox without any payment whatsoever the perpetual, unconditional, and exclusive right throughout the world to use and portray Michael Oher's name, likeness, voice, appearance, personality, personal experiences, incidents, situations, and events based upon or taken from Michael Oher's life story in connection with motion pictures and otherwise from dates mentioned in the Blindside book through the end of the 2008 NFL draft and non-exclusive rights to his life after the NFL draft. Because he's a football player, or was a football player. So if he's giving away the rights to all of that in any format, that was worth a lot more than $225,000. That's huge money. But Michael Oher believes that the signature on this document is very similar to his own, and he does not know whether the signature was forged. However, Michael does know and here avers that he at no time ever willingly or knowingly signed this document, and that nobody ever presented this contract to him with any explanation that he was signing such document or any document concerning his rights to his name, image, life, and life story to Fox or anybody else. This one is going to be This one's going to be a big argument because, again, Debbie's going to be involved in this. There's going to be some testimony. Now, a lot rises and falls on this claim. A lot of his claim hinges on this, because if they can establish that this signature was forged, if Michael Oher can establish this was forged, then holy crap, this becomes a big deal. It also means that that contract that Fox has, not so good no more, if that does not turn out to be the case. But the flip side of this is that if he did sign it, if there are witnesses who are credible, and if the court finds that he did sign it, then his credibility becomes way worse. So a lot of his claim rests on this particular thing. This is the weak point of his claim. And I hope for him that it holds up. Because if it doesn't, if this doesn't hold up, then the rest of this starts falling apart like a bit of a house of cards. There's still bad issues, but yeah. To the extent that co-conservators in any way facilitated the signature of Michael Oher on this unconscionably unfair document, whether by forgery, trickery, or otherwise, or even if they simply knew about it and allowed this miscarriage of justice to occur, whereby the co-conservators and their children would reap millions of dollars, while co-conservators Ward would receive nothing, they would have committed a breach of their fiduciary duty so gross and appalling that they should be sanctioned by this court by disgorgement of all sums of money received from this motion picture, plus interest from the date of receipt of any payment, and also required to pay appropriate punitive damages to their ward, Michael Oher, as determined by the court. All right, what's a fiduciary duty? A fiduciary duty is a duty to somebody that is over and above the duty to yourself. And so what that, and the classic example of a fiduciary duty is a lawyer's duty to their client. So for instance, if Aunt Debbie was representing Michael Oher, she owed him a fiduciary duty. I actually want to look back up. We're on page 7 here. I'm just going to scroll up. I'm wondering, like, this is a conservatorship. I'm wondering if we're going to see a lawsuit against Aunt Debbie too. But so a fiduciary duty ends up being a really big deal. So let's say, for example, that I, as a lawyer, I've got a client, and my client tells me, he says, I've got a great opportunity to buy this car. It's on Facebook Marketplace. The guy's selling it for $2,000. He thinks it's a broken down piece of garbage, but this is actually a rare car. This is actually like some special edition. Only, a certain number were made. It's worth, millions, even in poor shape. And my client tells me all of this just while I'm in his office. And so I go and I find that, and I tell the person online, hey, listen, I'll pay you $3,000 for that car. And the guy says, oh, sure. Sells it to me for $3,000. I have breached my fiduciary duty to my client. My client, I can't screw him out of money like that. And in fact, if my client and me, if I have to choose between whose interests I want to follow, if I'm a fiduciary of my client, then I actually have to put my client's interests above mine. I have to follow my client's interests, even if it hurts me. So, for example, let's say a client, let's say I represented a famous person, and I have, and I can make a whole pile of money going and talking about representing this famous person. Wouldn't be a problem. Oh wait, except I have duties of ethics, or that say confidentiality is a thing and privilege. But even if I didn't have those, I still have a duty, fiduciary duty to this client. I can't throw their interests under the bus in order to facilitate my own. All right. So, carrying on here. The Blind Side movie was released on November 20th, 2009, well after Michael had used all his NCAA eligibility at Ole Miss. As such, any remuneration he could have received from The Blind Side occurred after college and would not have affected his NCAA eligibility. This is important because you can get kicked out of the NCAA if you're making money on the side. Due to the massive success of the movie, Alcon Entertainment, LLC, the successor to Fox, made a donation to Leanne Tuohy's foundation, the Making It Happen Foundation, in the amount of $200,000 on October 10th, 2010, in the name of Sean Tuohy. Upon information and belief, this payment was triggered by an amendment to Life Story Rights Agreement of Sean Tuohy. And no time did conservators, Alcon Entertainment, or Fox inform Michael of the amendment or negotiations thereon, nor was there any amendment attempted to ensure that Michael would benefit from the movie's success, in contravention of the duty that the Tuohys had to Michael as his conservators. Now, I'm just wondering if I'm wondering what the board of directors of this foundation gets paid, because some charities pay out very little. Some charities basically, put that out as they want every dollar possible to go to people. There are people who lead charities who make like $40,000 a year, which is not a whole lot, And there's people who lead charities who make $500,000 a year or millions a year. And I'm wondering where they sit in this particular hierarchy. How much are they getting paid? All right. So, procedural background. So they're going to tell us the story of what happened. On December 7th, 2004, the Honorable Judge Robert Benham granted the petition, entering the order appointing conservators of the person, making the determination that Michael was in need of supervision, protection, and assistance, and that he should not be able to make contract decisions on his own. The order states in pertinent part as follows. We read this. Concerning the duration of the conservatorship, the petition indicated it is Michael's desire that the petitioners be recognized as his legal guardians, at least until he reaches the age of 25, or until terminated by order of this court prior to that time. Despite that prayer, the court appointed the Tuohys as conservators to serve in that capacity until further orders of the court terminating the conservatorship. So forever. He could have been, He could have been on there the whole time. He could have lived his entire life under this conservatorship. The official Shelby County Government Probate Court records show that a waiver of bond and the conservator certificate were issued on December 7th, 2004. No subsequent order terminating the conservatorship has ever been signed, nor have conservators ever moved the court to terminate or modify same, i.e., it's still in effect. Conservators have never filed any yearly accounting, nor moved the court for any extension of time to file yearly accountings as required by the law. So what does that mean? Every year they're supposed to provide an accounting of their, of their finances, to show that they're being conservators in good faith. Conservatives have never filed any required statement of fiduciary as to physical or mental condition of the disabled person to inform the court as to whether the conservatorship should continue as required by the law. So the law basically says you are required to file these things, show how you're dealing with the money, show that you're dealing with it responsibly, and also as a fiduciary, you have to basically say, we think the conservatorship should continue or we don't think it should continue. I.e., if somebody gets better, like let's say let's say somebody becomes there's a conservatorship established because they suffer a brain injury and they can't manage their affairs. But then 1 year, like 10 years down the road, just one day, they have a miraculous recovery and they're back to where they were. And nobody knows how. It was just, maybe they drank some holy water or, uh, went on a vision quest or whatever it is. Like maybe it was some religious event. They were visited by aliens, something. And they just have a miraculous recovery. Well, then you'd have to file a certificate to say, actually, they're better now. And, maybe we don't need to be conservators anymore. So conservators never sought to have the conservatorship modified to appoint other third parties as conservators due to the plain conflict that would and did arise between their fiduciary duties and their own personal financial interests related to the movie. If you've got a conflict of interest, you should deal with that, is basically what that says. Since at least August of 2004, conservators have allowed Michael specifically, and the public generally, to believe that conservators adopted Michael and have used that untruth to gain financial advantages for themselves and the foundations which they own or which they exercise control. All monies made in said manner should, in all conscience and equity, be disgorged and paid over to the said ward Michael Orr. This conservatorship is unnecessary as Michael Orr is capable of handling his own affairs. I mean, clearly, right? He's an adult. He's got no mental or physical disabilities. It seems like he should be able to run his business. Petitioner Orr asserts that under Tennessee Code, cited, conservatives herein should be discharged and the conservatorship terminated because of conservators' failure to perform their duties and obligations in accordance with the law, because of their failure to act in the best interests of petitioner Orr, and because Orr is not under any disability that requires a conservator. Quite frankly, if they signed a deal that basically says all of the natural-born kids and the parents get money, but he doesn't, that in and of itself seems to be a violation of their fiduciary duties here. When a court earlier determines that a conservator is no longer needed and issues an order terminating that conservatorship, the conservatorship shall terminate. Orr is not under any disability and is a well-respected member of the Nashville, Tennessee community. Further, conservators' utter failure to adhere to any of their legal duties and obligations as conservators as Orr provide a proper basis to terminate their conservatorship. You suck. You suck at what you're doing, and you're terrible people. Therefore, they should not be conservators. That's what he's saying. Should this court deem it necessary, petitioner is willing to submit to an examination as required by the law to support his contention that a conservator is no longer needed. I.e., he might need to go through medical examinations to say, are you sane? Are you mentally healthy? Are you able physically? Can you manage your affairs? Are you in a position to, shop for yourself? Are you in a position to wipe your own butt? Can you do all of those things? And I'm pretty sure that a NFL, football star can do those things. So since the conservatorship began in December 7th, 2004, conservators have had a duty to act in the best interest of Michael Orr. Conservators are appointed to act in the best interest of the disabled adult person for whom they are partially or fully responsible in the discretion of the court. How did they get this in the first place if he was never a disabled adult person? The trial court must specifically enumerate the powers removed from the respondent and vested in the conservator. A key obligation which conservators must meet is the care of a ward's property, assets, and account for such at least yearly, except as provided in subsection 1 within 60 days after each anniversary of the accounting required in subsection A, or any other end of an accounting period selected by the fiduciary after the subsection A accounting. The fiduciary shall file a sworn accounting with the court. So it's required. and it's got to be sworn. It's under oath. So, and we are 8 seconds from spicy time. 5, 4, 3, 2, 1, 0. Yeah, just like Brittany, no test needed to get into the conservatorship, but every test under the sun, invasive and non, to get out of it. Yep, that's so. Yeah, this one is just ridiculous. It just, I mean, assuming these allegations are made out, some people should, like, some heads should be rolling, and I mean that figuratively, not literally. But yeah, since the inception of the conservatorship, an important asset of Michael's has been the rights to his name, image, and likeness. This is huge for a sports star, right? Huge. Every individual has a property right in the use of that person's name, photograph, or likeness in any medium, in any matter. This court specifically removed the ability of Michael to enter contracts regarding his name, image, and likeness rights, and gave that right to conservators. Consequently, conservators had the duty to act in the best interests of Michael's rights regarding his name, image, and likeness, and to account yearly regarding those assets. What did you do with those assets? Did you, for instance, sign them over to Fox in order to get a movie deal? To date, conservators have filed no accounting and should now be ordered to fully account for what Michael's name, image, and likeness assets and use thereof by Michael's or conservators' benefit throughout the conservatorship, as conservators and their children collectively received millions of dollars. I don't think they did. And Michael received nothing for his rights to a $330 million deal. And I'm just trying to see. So, if they had points on the gross, then Michael would have been, or then they would have been looking at $8,250,000. But they didn't have points on the gross; they had points on the net. I don't think that they got anywhere near 8 million. I'm going to bet that they got something more like somewhere between the price of a cup of coffee and 100,000. That'll be my bet for where that actual money lands is that. So yeah, I'm thinking that's what we're looking at there. All right. Petitioner Orr asserts that absent the breach of fiduciary duties by conservators, Orr would not have incurred court costs and attorney's fees to submit this petition, and he petitions the court to award him all damages and relief, including court costs and attorney's fees the court considers appropriate under the law. So basically, I want my lawyer money back. As cited above, petitioner Michael Orr is suffering continuing damages due to the ongoing misuse of his name, image, and likeness by the co-conservatives herein, especially in conjunction with the continuing false claims that they adopted petitioner at any time. I.e., it really pisses me off that that they're still using my name and saying that I'm adopted when they never actually adopted me. So F them, they need to stop that. Consequently, petitioner is entitled to an injunction prohibiting conservators from using his name, image, and likeness. You got to stop that. So this is basically his prayer for relief. What does he want? He wants the sworn accounting. He wants them to pay over such sums received by them, plus interest. He wants his court fees. He wants sanctions for their misconduct and compensatory and punitive damages, and to pay, all of his legal fees and any other relief for which he's entitled. So this is his request. Now, there's some other, there's some other court documents that are sort of attached, but we can't really properly read those because they're interrupted. So let's have a look at some of those. But we're going to take a break on that because some people said, listen, I want you to cover the other side of the story. And we don't have the full other side of the story at this point. But we can cover the little bit of the other side of the story that has been released. So we'll do that because we want to be fair. I mean, his claims are big, but we want to see the other side. All right, so Sean Toohey says other claims or claims are insulting. We made little money off Blindside. I actually believe that they made little money off of Blindside. He's saying that they're insulting allegations and while insisting that they made little money. I suspect that they, as I said, I think that the net versus gross thing is, I think they got screwed on that. I think that they didn't realize that they shouldn't sign a deal, for net. So, yeah. Toohey told the Daily Memphian he never tricked Orr into getting a conservatorship and certainly didn't make millions off of it either. Then why am I reading it on TMZ? Let's go to Daily Memphian. So he responds to Blindside allegations. We're going to keep loving Michael Oher. Okay, that's a headline. So he said he was stunned when he read the allegations. And is that it? There's got to be more than that. That makes no sense. Okay, that's weird. I guess we'll read it on TMZ. Because somebody says, can Oher even get married without their permission? Yes and no. He can. Yeah, somebody said, is it a slideshow? It's not a slideshow. It's just a picture. Weird. He can get married. A marriage is not a contract, but he'd actually have trouble setting up the ceremony because, like, renting a hall or renting a facility would be a contract. Getting a caterer is a contract. Getting an open bar is a contract. Hiring taxis, contract. Limos, contract. All of that. So, yeah. What is it? Now, instead, Toohey said the whole ordeal went down because the NCAA told him if Oher wanted to attend Ole Miss, he'd have to be considered part of the family due to Toohey's status as a booster at the school. I sat Michael down and told him, if you're planning to go to Ole Miss or even considering Ole Miss, we think you have to be part of the family, Toohey said. This would do that legally. Or you could have adopted him. Like, you could have adopted him. That would have done it. He continued, we contacted lawyers who told us that we couldn't adopt over the age of 18. The only thing we could do is have a conservatorship. We were so concerned it was on the up and up, we made sure the biological mother came to court. Fair enough on making sure the biological mother came to court, but I just want to look up. I'm just pulling this up. Tennessee adult adoption. We're just doing some Googling on this. Tennessee law allows adult adoption. So, it does look like adult adoption is a thing in Tennessee. Okay. That claim is factually false, but maybe their lawyer just sucks because maybe their lawyer does too many different things and doesn't know what's going on. That's a possibility. Yeah. That is a possibility. What is it? So he says, as for the allegations that Toohey used the conservatorship to negotiate a big movie deal with Fox that netted massive profits for him and his family, Toohey said that simply never happened. I believe that. Again, they got net. They didn't get gross. So We didn't make any money off the movie, Tui said. Well, Lewis, the Blindside book author, gave us half of his share. Everybody in the family got an equal share, including Michael. It was about $14,000 each. I will have to see that. Like, we'll have to see what's going on there. Tui said he was in no need of cash after he sold his fast food franchises for over $200 million. I will say it's upsetting that people would think I want to make any money off my children. So, okay. I want to see his full filings. I want to see what they do to respond to this because, yeah. What is it? I see he never got any money from them for the movie and just found out in 2023. I mean, I suspect that he got some issue, or that he had some issues as to not real. I think that there's a dispute here. I suspect part of the dispute is that I think he thinks there's a lot more money here than there actually is. So I think he thinks that there's a lot more money here than there is. But there are all sorts of issues here. Like, let's assume that he got the 14,000, that was fair and whatever. They're saying that this is all on the up and up. Then where's the accounting? And wouldn't their response be like, hey, yeah, we'll let you out of the conservatorship because it's obvious that you should be able to sign contracts at your age. And it is weird that their page says the adopted son if he's not actually adopted. Like, I'd be annoyed if I found out that I wasn't actually adopted, but they said the adopted son. So I think I got some concerns on this one. I want to see what their response is, because I will give them a lot more credit if their response to the filing is, listen, we agree he should be out of the conservatorship. We didn't, there isn't any money on this, but we'll do an accounting. So yeah. I see the film was a commercial success, grossing $309 million on a $29 million budget. Yes, but the thing that is important is Hollywood accounting is a whole thing. And part of how Hollywood accounting works is basically a bunch of sub companies contracting with each other. And so those companies it's ways that they move money around. And part of the reason why they do this is there's funding for movies that don't make any money. So they make sure movies don't make money. There's also situations where people sign for percentages of the net, and those people always get screwed, always, because there just isn't, this is sort of well known for like the Hollywood circle. If you got paid 50% of the net, you would probably be getting paid less than like the grip on set. It's yeah. Whereas if you're getting paid 50% of the gross, you're doing great. So yeah. So I'm wanting to see. I don't know. I mean, based on the response, this may or may not be as nefarious as he's alleging. I suspect. Here's my suspicion. My suspicion is they signed a deal that promised money on the net. And they probably thought there was going to be money on the net, but there's no money on the net. I want to see that deal. I want to see a copy of that contract, because I want to see if that contract specifically says Leanne, Sean, Collins, and SJ all get to share in this 2.5%, and Michael gets nothing. Because if that's the case, then that's really nefarious. But if it's just that there's 2.5% to go to the family, then it might just be that he thinks there's more money than there really was. Like, I don't know. I got some real concerns. This was a bad agreement. This is a bad, thing. And I think, quite frankly, this lawyer has gotten herself into a pickle, because even if there's nothing nefarious here, she should have known better. Oh my God, she should have known better. Yeah. New York Post says they got $225,000 each. So if each of Leanne, Sean, Collins, and SJ, so Sean Jr., got $225,000 and Michael got nothing, then that's a concern. Somebody says, I still don't lots of people have said, why does it take him this long? I mean, I think he thinks he was adopted. That's what he said. He said he thought he was adopted this whole time, and has discovered that he's not. And that's a big deal. Now, marriage is not a contract. Marriage is something else. People who say marriage is a contract, it's not a contract. Marriage is not subject to contract law. It's subject to marital law. So, marriage, not a contract in that sense. So I don't marriage is not an issue here. It's just not a wrinkle on this one. Now, so he's got some other things that he wants to bring out. Now, I mean, I think this would be this would be a real kick in the in the teeth to find that out. So let's have a look here. In the case of Michael Jerome Williams, aka Michael Jerome Orr, first set of interrogatories propounded to co-conservators by petitioner. So these are basically legal questions that he is asking. Legal questions that he's asking. So things he wants to know. And there's going to be a whole bunch of definitions. They define documents in the broadest way possible. They define communication in the broadest way possible. Conservators is Sean and Leanne Tui. This is all boilerplate defining stuff. But they also refer to the Making It Happen Foundation, persons, terms internet photos. Yeah. Term The Blind Side refers to the movie. Term Tui family refers to all the Tuis. So, all right, let's have a look at what he wants. These are things he wants. If you answer an interrogatory by reference to business records from which the answer may be derived or ascertained, please, and give details. All right. What is the information he wants? Interrogatory number 1. Please state your full name, date of birth, current address, and each address where you have lived for the past 8 years, occupation, social security number, and driver's license number. All right, so that's the first thing he wants to know. Interrogatory number 2. Describe your relationship with Michael Orr from 2004 through the present, including but not limited to the legal standing you've had regarding Michael Orr for each year, which is going to be conservatorship. Describe in detail the reasons why you sought conservatorship of Michael Orr. Okay, so please explain that. Describe in detail all actions taken by you to prepare to become co-conservatives of Michael Orr. Next, describe in detail why you chose to obtain a conservatorship instead of formally adopting Michael Oher. Next is identify all instances, including but not limited to public speaking, your blog, and Making It Happen Foundation, where you have referred to Michael Oher as your adopted son. That might be a lot. I suspect that's going to be a whole lot. Interrogatory number 7. So the 7th question he wants to ask. Identify and describe all instances where you have received financial gain for referring to Michael Oher as your adopted son. This one is subject to some questioning. And I'm just going to star this. Jenny in GA, is that Georgia? I'm going to respond to that question in a moment. We're just going to go through the interrogatories here. Identify and describe all instances where you have received and expended monies from contracts and agreements relating to or entered into by you on behalf of Michael Oher. Describe in detail, including dates, all communications you've had with Michael Oher's mother, Denise Oher. That'll be interesting. And I'm going to also tag that one for response, hopeful human. For any and all expert witnesses who will testify in this cause, please state the substance of the facts and opinions to which the expert is expected to testify, and a summary of the grounds for each opinion. I'm guessing they put that into everything. There's more things for expert witnesses. What are their qualifications? What are their other cases in which they testified? And a statement of the compensation to be paid for them. Number 12, if your experts rely on any learned treatises, we want to know what things they're relying on. If you've ever been party to another lawsuit, either as plaintiff or defendant, we need to know those details. Have you ever been convicted of or pled guilty to a crime, including youth court? I'm guessing they put this into everything. I don't see that the Tuohys would have likely had a criminal record, but maybe. Please identify any documents or other physical evidence that you expect to use at the trial of this cause, or you expect to introduce into evidence at the trial of this cause. Describe in detail all communications, all of them, concerning Michael Oher. Describe in detail all documents and communications, including but not limited to contracts, agreements, and notices concerning the blind side. Describe in detail all documents and communications and royalties paid to you or the Tuohy family or any foundation from the Blind Side book or movie. So now, somebody had mentioned a some other quotes here, so I'm going to try to bring those up when I can. All right. Interrogatory number 19. Describe all negotiations by you on behalf of Michael Oher regarding the Blind Side book or movie, including but not limited to all NCAA regulations on which you decided that Michael Oher was to receive no monetary payment for the sale of his name, image, and likeness rights. Describe all contracts and agreements relating to or entered in by you on behalf of Michael Oher. Describe all documents and communications relating to the Make It, including but not limited to records of monies received by you or the Making It Happen Foundation concerning Michael Oher, appearances by the Tuohy family, The Blind Side, 20th Century Fox, Alcorn Entertainment, or Alcom Entertainment, I'm not sure which it is, books written by the Tuohy family, including but not limited to their books. Describe in detail all documents and communications concerning your representation that Michael Oher is your adopted son. Please identify any and all photographs, still images, and video image sharing sites you've used and maintained an account with since 2004. Please describe in detail any and all content you have deleted or erased from August 1st, 2023 to the present, which refers to Michael Oher, including but not limited to photos, videos, posts, tweets, and username changes. Describe all payments made to you or the Tuohy Foundation from the Making It Happen Foundation. So that's a giant list of things they want. Oh my God. All right. Now, I said I would look up something else here. Somebody else referenced something, so we're going to bring that up because apparently SJ Tui made some comments too. Everybody's talking to the press. Why are they talking to the press? And yes, this is a good point. A prenup is a contract. The marriage isn't a contract, but the prenup is a contract. So the biological son of the Tui family discussed the situation Monday. So, I get it. Why he's mad, SJ2E said. It stinks that it'll play out on a very public stage. That part sucks, but oh well. So, yeah. He says, I've never once talked about, truthfully, how much money I've made off the movie. But candidly, I mean, I don't really care that much. It's going to be public record now anyway. But I remember I got the first check. I was at the University of Arkansas as a member of the coaching staff. We were in Memphis. We were. I'm trying not to get me illegal recruiting implications. I was around my house at the time. I met my dad for lunch, and he gave me a check, and I'm like, "We get paid off this thing?" He's like, "Yeah, it's made so much money now that they can't hide it. We probably, as in me personally only, because I can't speak to that, I've made like 60 or 70 grand over the course of the last 4 or 5 years." Okay, that's more money than I thought. That's a lot more money than I thought. It's a lot more money than I thought. Why is the son getting money for the movie? Because apparently, according to the contract, everyone got money for the movie except Michael. So, yeah. Okay. Interesting. That is interesting. Now, I'm just trying to see. Somebody said that there was a quote where he said that there was blackmail, and I'm trying to find that quote because that seems interesting. So further quotes from Sean Tui. He says, the last thing I needed was 40 grand from a movie. I will say it is upsetting that people would think I would make any money off my children. Oh, that's Elder Tui. I mean, if you don't need the 40 grand, I could use the 40 grand. Ship it my way. Whoops. Michael was obviously living with us for a long time, and the NCAA didn't like that. They said the only way Michael could go to Ole Miss was if he was actually part of the family. Yeah, I got questions. There was a somebody said that there was a line about blackmail somewhere. That's not coming up anywhere. So yeah, I don't see that. I mean, we'll have to see. That'll come out in the accounting as to how much money everybody got, but we'll see. And I want to see the response. Like, as I said, there's some really interesting wrinkles on this, but it looks bad. But everything, I mean, the other thing is, it should, when you file a lawsuit, it should look bad from the outset. If your lawsuit filing, if you get a lawsuit filed and you're not sitting there and a reader doesn't go, ooh, they're screwed, then you have done a bad job of filing that suit. All right. Now there's some other documents that are still out there. So this is a subpoena, and it's a special kind of subpoena. It's a subpoena called a subpoena ducis tecum. I'm not sure the pronunciation. I don't really deal with these a lot. They don't come up a lot. But what these are, and Latin pronunciation is basically made up anyway. And that is a good question. Adult adoption legalized? What year did it become legal? I don't know if there's any particular... I don't know how I'd find that out, but so when did that become legal? I'm not sure. I would have to do some digging around, but yeah. All right. So the subpoena ducis tecum basically is that you are telling somebody that they have to come into court, but the main reason why they're coming into court is to bring documents. It's bring the documents to the court. So really, this is a kind of subpoena to get paperwork, is what it means. So they go through all of the same definitions. We're not going to go through the definitions, but this is going to say the paperwork that they want, and they want this from the Making It Happen Foundation. So that's where they want this. All documents and communications about OR, everything about money involving all of that. Now, this one is interesting because I can tell you what the response to this is going to be. All documents concerning payments made to Deborah Brannon from you. You know what the answer is going to be on this one? You know what the answer is going to be? The answer is going to be, go fuck yourself. This is privileged. That's what they're going to respond with. Because Deborah Brannon is counsel for for the organization. So they're going to be told, you can't have it. Go away. All documents concerning payments made to the Toohey Foundation from you, or Toohey family. So basically, we want to find out how much the Tooheys are making from this foundation, Michael says, and that is going to be huge. So, yeah. Names and business and home address for current officers and directors, i.e. the Toohey family. Please produce your membership lists. Your charter and all amendments currently in effect. Your bylaws and all amendments currently in effect. Written communications to the members. All documents, reports, and filings between you and the Tennessee Secretary of State. All meeting minutes from the beginning of time. And yes, that's Auntie Debbie that they want. Apparently, Vanderbilt Law Review says adult adoption in Tennessee since 1949. I think we can take it as a given that he was not alive in 1949. All records of board meeting member actions taken without a meeting. Record of actions taken by board committees is delegated by the board. Your accounting records, including annual financial statements, and records of persons or organizations receiving monetary assistance from you. I.e., we want all the books for the charity. All the things. Now, the next one they want, and this one goes to Deborah Brannon. That'll be her law firm address, by the by. These are publicly available records. Like, I just pulled these off the court webpage. So I'm not doxing anybody. This is all off the webpage. But Auntie Debbie, Deborah Brannon. All right. What do they want from Auntie Debbie? Keeping in mind that Auntie Debbie has had various legal relationships with people. They're going to have to try to crack through the privilege issues on lots of things. All documents and communications concerning Michael Oher. Now, here's the thing. If Debbie was purporting to be counsel for Oher, then no privilege exists with respect to Michael Oher. This is a thing I have to warn people about all the time. There isn't, in my area and in most areas, there isn't a rule against representing multiple people unless there's a conflict of interest. So unless there's a conflict of interest, you can represent more people or more than one person. And sometimes in criminal law, that means I can even represent more than one person charged with a crime. So, for example, let's say let's say a husband and wife are driving a car and they get pulled over, and in the trunk, the police somehow have a look in the trunk, and there's a kilo of heroin. Right? Now, husband and wife do not want to get convicted for possession of a kilo of heroin, because that would be possession for the purpose of trafficking in, you know, in substantial quantities. That's at wholesale amounts, and therefore they would get lots of jail time. So, husband and wife come to me and they say, we want to hire a lawyer, but we don't have the money for 2 lawyers. And I say, okay, cool. What's your defense likely to be? And, you know, if the defense, like their defense might be, listen, we didn't know the heroin was there. We loaned this car to our, you know, our kid. Our kid is a real troublemaker. Our kid's, you know, full of crap. We don't like our kid. Our kid is a troublemaker. We try to do the best for our kid, but that's our kid's heroin. That's who that was involved. So, and, you know, so at that point, mom and dad have the same defense. So I might be able to represent them and represent them together. But I give them a couple of warnings. There are a couple of warnings. The first warning is, listen, if your argument changes at any point from it was our kid's heroin to actually it might have been the other person in the car's heroin, I didn't know it was there. It was their heroin. Now I can't represent you. I have to get off the file for both people. I can't represent either of those people at that point, because now there's a conflict of interest. And once that conflict of interest arises, my having represented them both means I can't represent either of them anymore. So it's not like I can be like, oh, well, I'll just represent the husband then, or I'll just represent the wife. I am foreclosed from representing either once that conflict arises, which is a thing that Debbie might need to worry about, those kinds of ethical obligations. The next problem that comes up is, let's say one of them tells me something and they say, don't tell the other person. Well, no confidentiality or privilege can exist in that relationship, like in that place. So as an example, my wife and I, we bought a house together. In fact, this house, the one I'm in right now. And, you know, we hired a lawyer to represent us, and they were both there. Like, the lawyer was representing both of us. So, you know, the lawyer was very careful to warn and say, there is no confidentiality or privilege as between you and your husband. Good warning, right? But if Michael Oher is if she was also representing Michael Oher in this transaction, then there's no confidentiality or privilege. And he's entitled to these documents. So that'll be fun. That will be fun. What happens if you don't recuse yourself when it arises? Whichever side is unhappy with it would be able to have me kicked off the file, and I would also face ethical sanctions. So, yeah. I hope you got an RIC's report for the house. I could tell you some stories about the house and our adventures with it later. What is the worst case scenario for Debbie? I mean, this is hypothetically if the facts bear out the worst possible interpretation, and that would be disbarment. But that would be if the facts support that she was working for the Tuohys in order to screw Michael Oher over while also representing him as a client, then that would that would be a problem. So, yeah, but I don't know if that's the case, right? This is if. So, yeah. And I see Nicholas is saying adult adoptions in Tennessee have been legal since 1996. And all of this happened after 1996, I believe. So I'm just checking the timelines again. When did they get this conservatorship? 2004, which is after 1996. So, yep, not a problem. All right. What else do they want from Debbie? They want including but not limited to all documents and communications, including but not limited to contracts, agreements, and notices concerning the blind side, because she was counsel on that somehow. All documents and communications, including but not limited to record of monies received by the Making It Happen Foundation concerning or relating to Michael Oher, appearances by the Toohey family, The Blind Side, 20th Century Fox, Alcorn Entertainment, books written by the Toohey family, including but not limited to all the books. All documents concerning payments made to you from the Making It Happen Foundation. Now, some of those, I think they're going to see some privilege arguments. I think we're going to see a lot of this. I just want to know how is it that that she does all of these things? Like, she's there on the family file, she's there on the entertainment file, she's there on the foundation. Like, usually a lawyer specializes a little bit. I got questions. I got so many freaking questions. All right. Yeah. So many freaking questions. Because, yeah. All right. Let's have a look. We'll cover some of the member chats and also, what is it? Betting Debbie, Aunt Debbie also helped SR with selling the franchises. Maybe. All right, let's look at the super chats here. I'm gonna swoop. X Off Grid, thank you very much for the YouTube membership. Much appreciated. Time, conservator versus power of attorney. Well, in this case, the conservator included a power of attorney. Vez from Quebec, thank you for the sidebars from Depth v. Heard and the Monday Fun Day stream. You're awesome. Thank you so much, Vez from Quebec. Always nice seeing you in the chat here. How does court-appointed power of attorney work? Power of attorney, you have all those powers. You are typically a fiduciary, so you are required to act in their interests. But people abuse power of attorney all the time. It's a thing. Whoops. Molly, thank you very much for the membership there. Zen Girl, thank you for the membership. Much appreciated. How did the Ravens and his agent not notice this? Well, how would they? How would you, like, if you had a, he thought that he signed adoption paperwork, basically is what he's saying. And how would you know that this was an issue if you didn't realize that you were under these terms? And you're probably, you probably make agreements all the time without asking questions like, are you under a conservatorship that means that you don't have power to contract? I hired a guy to mow my lawn a while back when I was, when I had my appendix out. I hired a guy to mow the lawn. He didn't ask if I was under a conservatorship, and I didn't ask if he was. He mowed the lawn and I paid him money. So, yeah, you wouldn't notice, because how would you think to check, right? If true, this sounds like slavery with extra steps. It does sound a little dark. I don't want to go so far as to say slavery, because it sounds like he still got paid for his NFL stuff and so forth. It just sounds hinky. I guess hinky is a good word for it. just sketchy. All right. Memphis Tiger, thank you very much for the super chat. Much appreciated. Runkle, are you going to look into Linus Media Group auctioning off a prototype that did not belong to them? Gamers Nexus did a video on it. Possible theft by conversion. I am torn on that one. I will have to watch the Gamers Nexus video on it, see what they're looking at, and then make a question. I have to decide whether or not that would be something that I feel is within my ethical rules. I don't like doing videos where it might get somebody arrested. So I'd have to think. I'd have to think on that one because it's already been reported by someone else. But I do know that there is a lot of there's a fair bit of law enforcement that watches my videos. So I got to think on that one. It's a good question, though. Memphis Tiger, SJ says he received 60 to 70K per year for the last 5 to 6 years. Okay, that is big money. If it's 60 to 70 a year for the last, I mean, I would like 60 to 70,000 a year for the last 5 or 6. If anybody wants to pay me 60 or 70,000 a year, like, we'll talk. So, Nicholas Starro, what was his salary in the NFL and what sponsor deals was signed? Those monies must be accounted for as well. I assume he got those monies. I don't know. So, yeah. And I'm seeing officers' compensation, $0 for each of them. In that case, good for them. I also want to know which things that are not compensation that they got. For example, flights, travel, that kind of thing. So, yeah. The other thing is, at a certain point, when you've got lots of money, one of the things that wealthy people start trying to do is to rehabilitate your image, and so that may be an issue on that as well. So, I don't know. I am just gonna have to I'm gonna have to wait and see. I want to see on the other side because, I mean, the argument of, hey, we just thought that we were, trying to get him into a college there. It could be borne out. It could be that that's the case. In which case, this is a tragic dispute over hurt feelings. And that's fine too, right? So, yeah. All right. I love this movie. I feel betrayed. I cannot imagine how Michael feels finding out he was not adopted. Yeah, I mean, that's a rough one. It seems to me that if the issue was over adoption, maybe they should have talked and said, hey, can we fix this? Like Tennessee does adult adoption and so forth. So, yeah. Because if they do want to be a family, if everybody likes each other and wants to be a family, they could fix it. Best runkleism so far, the Swiss Army knife of lawyers. Yeah, I mean, it's not necessarily favorable. Bez from Quebec, adopt me, Ian. You'll get a wonderful daughter nearly 10 years older than you. I'm worth it. It's a lovely idea, but oh my God, the paperwork. I think I'd also have to meet you first. So I'll have to make a trip to Quebec sometime and say hi. Tuies are claiming in some articles that they were told they could not adopt an adult. Wonder who told them that, or if they're backpedaling or lying. All of those are possibilities. It's a possibility that Aunt Debbie's just not very good at that. So, yeah. I guess no one ever checked the legality of his contract agreement, cars, apartments, phones. Why would you? Like, if you buy a car, they're not going to be like, hey, so are you do you happen to be under a conservatorship right now? Yeah. Latin pronunciation is made up. I saw on the interwebs that someone has a tape of original Latin being spoken. Maybe. A lot of Latin pronunciation was lost. So, how was he able to sign the NFL contracts when the Tuohys have to be involved since they were the conservators? I think honestly it was probably just nobody checked. Is really what that was probably about. Jill with Graceful Answered Ministries, thank you for the YouTube membership. Jill, if I recall correctly, did a thing with Stephen Gosney recently. So I saw in the chat lots of people are fans of Stephen Gosney's discussions. So check out Jill with Graceful Answers. She talks religion, which isn't really my speed, but she does it in a sort of an interesting way. And she has, if she had Gosney on to talk about things, so go check it out if that's of interest to you. Kristen M96 just saying hi. So hi, hello. I got to talk to you about commissioning a robot because, it's also sad joining from UK at 4:14 a.m. It is, as I said, this is a tragic circumstance because this is either a promising young kid who was seen as a piggy bank and was ripped off, or it's a tragic circumstance of a kid feeling betrayed because he was never really made part of the family when he thought he was made part of the family. And like, either way, it's sad, right? Either way, it's super, super sad. And that's tragic. So I really wish that this story was different, I guess, is, things at the end of it. And I don't think that anybody, he made millions out of the NFL, so he's probably fine for money, assuming he's behaved it reasonably. So, yeah. All right. Thank you, Lahaim. Well, thank you very much. And I saw Askieshka also donated 5 gifted memberships. So thank you very much. I hope my pronunciation of Lahaim was all right. My throat is not the best, so I'm not going to try that again. Nanner always carried power of attorney papers for my dad. Alzheimer's. Alzheimer's is a really, it's a classic example of where you might need it. Just because that person might not be able to manage their affairs. Koru says, how do you know law enforcement watch your videos? I have talked to the chief firearms officers, people at the CFO's office, and they said, we watch your stuff. I've talked to police officers who said, we watch your stuff. Literally, I've talked to police officers in uniform. I was walking downtown in Edmonton at one point, and an officer walked past me, did a double take, spun around and said, you. And I went, what? Because when you see an officer do a spin and go, you're like, holy, what the? And he goes, you're Runkle. And I went, yes. And he's like, I watch your stuff. It's great. Have a great day. And he kept walking. And I went, I got to change my underwear. So, yeah. That was a moment. But yes, clearly that officer watches my stuff and also scares the crap out of me. Lion by the Sea. So they didn't interfere in contracts, etc. after TBS. That's probably why I never questioned if adopted. Yeah, probably. Can't I give my sister a limited power of attorney to sell my cottage in New York? She's a retired lawyer and lives 2 hours from my property in New York, and I'm stuck in Louisiana. I can't give you legal advice on this one, especially not on power of attorney, because power of attorney is, as mentioned, radioactive. You should talk to a lawyer about power of attorney. It might not be a problem. It might be a big problem. Talk to a lawyer. Um, yeah. Tim Riggs, what bothers me most is the years of failure to file certified accounting and the apparent disregard of his personhood by not uh, prospectively ending the conservatorship. Yep. And yeah. Um, yeah, I think another big issue and is just the aspect of I think he wants to tell his own story. I think he didn't like the Blind Side story on all of that. I think he also wants to, if he can, reclaim his likeness rights. I think he wants to, to reclaim whatever he can on that. I think he just doesn't want to be. I think he, wants to have his legal standing back. Like he absolutely needs out of this conservatorship. 100%. No matter what else happens, he needs out of the conservatorship. All the rest of it, I think, is gravy. But, I mean, if you found out that you weren't somebody's kid and that they never really thought of you that way, that they never actually took the steps to adopt you, you would probably want them to stop publicly saying that they were your kid for grifting purposes, which is really what he's alleging, right? He's really alleging that they're grifting off of a lie about him that is tragic in his backstory. So, yeah. Is he still in a conservatorship right now? Yes. He wants out. That's what he's working on. And yeah, I think he's always hated The Blind Side because it called him dumb. I would not want a movie to call me dumb either. Yeah, me either. All right, so we've covered Or. I think I'm going to wrap things up. And the reason why I'm going to wrap things up, I kind of wanted to get into a little bit of Leah Remini, but I'm not going to do that today. I'm going to do that when I can. Guys, please hit the like button if you haven't already. Share this video out, for people on replay, all of that stuff. I'm going to wrap this up because my throat is starting to give out, and I am going to, I'm going to fail. Oh, did I see the fireworks issues in Summerside? I did. I actually want to ask some questions about that because I want to find out which company was involved, or if it was a company. So yeah, for the people who don't know, there's been reports that a fireworks show went wrong and fired into the crowd. So I want to make some inquiries on that one, and that there's some other things I want to cover, and that I was thinking about talking about. One of them is the latest with Jessica Simpson / Jessica Yaniv. I think I got to leave that to another night. I am, my throat is getting to me. I'm sort of, it's all sorts of bad. So I'm gonna go cough up a lung and then sleep. I think is. I'm only lying about the sleep. I'm going to go cough up a lung, and then I should go to sleep, but I'm probably going to screw around playing Baldur's Gate 3. And also, I'll share with you guys something that I've been playing lately. It is... I've been playing a game that... this is kind of... this is a really cool thing. This is something I kind of want to share. It's not open to the public at this point yet, but it's really cool. So there's this game, A Mud, I used to play 25 years ago. 25 years ago. So I was just a little youngster. And what happened with this Mud is that they started experimenting with... a mud is like a text description where you go, like you play a sort of D&D sort of game, and you online, and you run around fighting monsters and that kind of thing. And a lot of them are not very good. This one was excellent, like so good. And Like, it was so well designed. It was so good. I loved the hell out of this game. I still love the hell out of this game. And then something bad happened. And the bad thing that happened was that they started making a graphical mud. And the reason why that was bad is that when they made a graphical mud, this was around when MMOs were starting to become a thing. So various companies were trying to make MMOs. And as part of making MMOs, they needed some technical experience. Now, the people behind the Magic Realm started making a graphical mud, i.e., an MMO, which was going to be called the Twilight Lands. And the Twilight Lands never actually became a thing because Electronic Arts bought this. Electronic Arts bought out the company in order to get the stuff for the Twilight Lands. And so then they took the Magic Realm, which was this game that I loved, and they put the servers into storage. And those servers were basically lost. They were then recovered by a fan of the game, and that fan has managed to get the game back online. And I'm just trying to see if I can share that with you. Share screen. So stop sharing, present, share screen. It won't share. This game is now back online. I've just connected to it right now. I wanted to show you the game, but I can't because technical difficulties. It is amazing to have something from your childhood that you thought was lost and was a treasure that you thought was lost show up again 25 years later. It is an absolute mind twist in the best ways. So now here's the thing. This game, the Magic Realm, may eventually come back online and be available to the public. And so if it is, you better believe I'll be saying you guys need to sign up for this and come play with me, because that would be awesome. So anyway, I'm going to wrap everything up here. I'm going to play the outro. I do think I have one last super chat or a couple thing here. Joe Loy saying, thank you for highlighting real people's plights. Thank you. I think you're talking about my Twitter thing there. Amber, feel better soon. Thank you very much. Much appreciated. There's also Time. Thank you for 10 gifted memberships. So I'm going to try to, I might do a Roll of Law episode on this mud coming back, because I think that's cool. But anyway, I'm going to wrap things up and see you guys next week.